organized by Democracy in Georgia and a group of independent lawyers in the framework of International Network of Judicial Reformers with support of USAID Rule of Law Program. And so we will focus today on the role of vetting processes and also what alternatives are introduced to the vetting to ensure the accountability of judiciary. As you know, the vetting is typically applied as an extreme case where other mechanisms have failed, and its invasive nature often raises concerns about judicial independence and state sovereignty. In Georgia, the importance of conducting vetting and discussions about implementations of it became very active after the recommendation of Venice Commission. It was in October 2023. And it was recommended to implement the comprehensive reform of the High Council of Justice. After it was followed by the European Commission's recommendation to establish a system of extraordinary integrity checks with the involvement of international experts. But unfortunately, this process has been pushed to the background when the ruling party in Georgia introduced and adopted the law on transparency of foreign influence. In the streets, we had massive demonstrations protesting citizens of Georgia this law. After it was the attention to the parliamentary elections in Georgia, and there was raised serious suspicions of electoral manipulations. A lot of evidence were submitted to the court, but there as we have a very low trust to the independence and accountability of judiciary, and also it was followed that no one of the lawsuit was satisfied. This all proves against the importance of the judicial system as a guarantee of defending human rights and finding the justice in the country. Vetting and alternatives of the vetting, I think that is most relevant topic now, mainly for the Georgia. And professionals today and our experts who are attending and will be leading our discussion will speak exactly on this topic. I think it will be very interesting to hear their experience. These experts are directly involved to the processes, and they are also the members of SILI network and editorial board of publication on judicial vetting and alternatives of the vetting, on what they are now working exactly. So let me pass the floor to them. We will have two parts of the discussion. We'll begin with the systematic challenging facing the judiciary. Our expert, Buro Imnadze, who will join us, I think, in 10-15 minutes. So we will, he is an expert, and he is the director of Justice and Democracy Program, Center of Social Justice. So I will pass first the floor to Judge of North Macedonia, Georgi Andonov, who has recently took a position in the Court of Appeal. And after we will listen, the second part, it will be judicial vetting and alternatives to judicial vetting, where we have a very relevant and very professional expert, Mr. Andrei Bozinovsky, legal expert and coordinator of the guidelines on judicial vetting. Unfortunately, Dr. Grigor Burkovsky, the judge and international rule of law expert, could not join us today because he has some delays, and but we have Mr. Herman von Hebel, who is the chair of the Pre-Vetting Commission in Moldova, Moldovan experience with pre-vetting and later vetting. So now I will pass the floor to Georgi, who will introduce us what the problems and obstacles have the judiciary in North Macedonia and share his experience about this topic. Please, Georgi.
Thank you, Keta. First of all, I would like to thank you and the Democracy Index for the invitation to be part of this relevant panel on such important issues As we discussed previously, my country, North Macedonia and Georgia, share a lot of similar issues regarding the judiciary and the whole situation in the society. And I would like to mention that I'm very glad that someone is not having trouble with pronunciation of my name, Georgi. It's similar in Georgian, so I'm very, very glad, because it's very difficult for others. Okay, I would like to start with something that we spoke before, and that is that we live in difficult and uncertain times. This geopolitical crisis and processes ongoing in the world are inevitably leaving society in uncertainty, and this affects judiciaries in all our countries, especially in countries like North Macedonia and Georgia, who are post-socialist countries, and where change and shift from one system to another system create so much difficulties, and we're still ongoing process of reforms. Our judiciary in North Macedonia is being under heavy scrutiny for actually for the whole time, because it depends a lot of our work. Constant reforms and efforts to improve and establish a reliable judicial system have failed so far, and we're still constantly trying to establish it, but this process is, in my opinion, lasting too long. That's why the public trust in our judiciary generally is historically low. To be more precise and frank, this public trust is not concerning only the judiciary, but the whole branch of the government, where judiciary is only part of it. The political pressure and desire to overshadow and control judiciary are one of the main reasons that public perceive our judiciary as captured judiciary. The perception is that political elites and business elites have influence so heavily in the judiciary that actually we cannot speak about judiciary that is really independent in the terms as it is. This is also mentioned in the reports issued by the European Commission for this year. It's a report on the rule of law and the report of the progress of the country, and this is mentioned as one of the main factors about the unstable and judiciary and the low perception of the judiciary. Even now, with the change of the government, there are talks about even dissolving the Judicial Council and the Council of the Public Prosecutors. The idea that was brought by the current government, and now this is also a major concern, not only among our citizens and the judiciary, but also among our international partners. Of course, there is no doubt that results in the past in our judiciary have shown that we need to recompose and redefine those two governing bodies of the judiciary, but still it needs to be done in a one transparent and open process, not by act of the government, which was actually the basic idea, which is now actually basic idea of the current political forces. Of course, we need to address other issues because not only the political factor is pressuring us, but still we need to address the systematic challenges that we are facing in our judiciary, and that is the lack of judges and staff, because our courts are now understaffed in both administration and judges. For example, in our courts, only 1 year ago, there was number of 500 judges, and now it's only 350. So this is a major concern because judges are working with a significant backlog of cases. They cannot perform their duties and execute all the cases that are in work for them. Also, staff is a major concern because our courts work with only half of the staff needed for functioning, for regular functioning of the courts. This is all due to the neglection of all governments towards the judiciary in the past decades. They failed to create a healthy environment in our society where our judiciary will function properly and efficiently. One of the main reasons are that our budget, the judicial budget, is not independent as it should be. This is also a major battle that we're leading now and seeking for independent budget, because for now our budget is actually dependent. We are not receiving the chunk of the budget that we are actually we need by constitution, and we never did. And also, for example, if there is a need for employment for all the places that are empty and vacant in our courts, first we need to get approval by the government if there are enough financial funds, and then we can turn the process for employment of staff. This is something that causes difficulties in regular work of judges. I myself was president of the basic court, and I had difficulties in managing the processes because of the constant lack of staff. So the financial side, the financial issue is something that I emphasize a lot as one of the major reasons for the inefficiency of our judiciary, and this again needs to be addressed towards the governments that are governing our country. Other issue that I would like to mention is that we need to reorganize our judicial network. I mean, we had this census a few years ago, and this statistically shows exactly whether we need this current judicial network as it is, or it should be redefined. We have courts in remote parts of the country that are actually empty, without judges, without staff, with only small number of people living there, because there is a lot of a great migration from Macedonia towards Western countries. So this also provides inefficient courts that actually draw money, they draw staff, and they're still not efficient as it should be. So this is one of the things that are actually planned in the strategy for reforms for the next 4 years. But I was a member of this working group that worked on this strategy, and we actually established that half of the goals that were in the previous strategy were not realized and fulfilled. So we transfer half of them into the new strategy, and there is no responsibility for not realizing these goals before. Also, we are planning to, or maybe not planning, but we're working on issues of judicial jurisdictions of cases, because our backlogs are caused by inefficiency of state agencies. We have a lot of cases that are actually from the labor cases that are citizens and employees of the state agency are suing the government, and this is a really large number of cases that are jamming our courts. If the state and the agencies provide and fulfill their responsibilities towards the citizens and the employees, then we will be relieved from these cases. Also, misdemeanors and some administrative cases could be transferred to another jurisdiction, so we could work and manage only cases that are really in judicial jurisdiction. Also, big factor of inefficiency and that causes inefficiency in our judiciary is no real digitalization of the judicial system. Although for years we're speaking about it, we are hoping that it will be fulfilled completely, yet no government until now have fully supported and really get into the process. For now, there is only like intentions and good intentions, and some processes were put in wheels, but still we lack the full digitalization, and this means not only online judging, but also interoperability between the courts and the other relevant partners, that connection of databases, which will speedy the process of the courts. Statistically, also we need statistical tools for our purposes. So this is something that we are waiting for, and in my opinion, it will really be a way to promote more efficient judiciary. Also, we need to recognize that not only our problems comes from outside of the judiciary, we have to manage and work with the judges who are, let's say, the perception is that they are corrupt and inefficient, and we're struggling to fight against this. So there is a form of clientelism, perhaps. The perception is that there is a form of clientelism, there's a sort of corruption between the judges. So we need to promote judicial activism in order to make them more, to encourage the judges to be more open and to resist all the pressure that are experiencing. There was recent developments in the field of salaries of judges, and this is also a big factor for the judges, whether they should be motivated or not for working with this. But the government, let's say, simply frozen our salaries, and the Constitutional Court supported this. We were very disappointed, and we are now considering our next steps, maybe the European Court of Human Rights, or other steps that will mean that we need to continue our struggle for the rights of judges, because we live in a society where judges are feeling constant pressure, both from the elites and from the general public. The general public is in the opinion is created by media, which are heavily influenced by these elites, and we are struggling with it. That's why we established the Judicial Media Council as a part of the Judicial Association. Andre here was actually the spiritus movens of this effort, this endeavor of our association, and now we're living in the 6th year of this council, and yet we struggle to get results that we were hoped for. We are recognizable now. We have our our website. We have issued opinions. We established a school for journalists and judges, but still, general public. It's hard to shift and change the general public because of the nature of our work. So, in general, these are the few main factors and structural, systematic challenges that we are facing during this, let's say, 3 or 4 decades of independence. But I will emphasize the most important one, the only one that actually depends everything on it, and that is the political factor. If there is a political will and for stability and for improvement in the judicial factor, then everything will follow and be placed in order very, very easily. So I hope that these are some of the issues that are similar to your country, and we can share our experience and work on it and succeed together.
Thank you, Georgi. It was really very familiar, the situation in judiciary in North Macedonia. I will share information that Georgi has in the chat. We have these 2 documents of EU Commission documents on rule of law 2024 and also the progress of the North Macedonia, and you can take these documents and see. I think it is very interesting ones. And of course, thank you for this information. And I think that such judges who are struggling and still are inside the system, but struggling for independence and accountability of judiciary is very important. I see also that our Georgian judges are attending our discussion now, who are also very active in their fight against the corruption and developing and for the accountability and independence of Georgia. And thank you for them also for this and you. And I think that we can move on and leave the questions after the end of the discussion. I will leave this floor to the audience. And now I will ask Andrei to share his expertise and ask our questions and share information. What means this alternative of vetting, and it is the additional tool to the vetting, or it is a separate one? And please make your presentation and information share with us. And the floor is yours, Andrei.
Thank you so much, dear Keta. I will share the documents later after my presentation. It is funny thing that Georgia just texted me. I forgot to mention about vetting in North Macedonia, the discussions the government is preparing about vetting. Please, Keta, note that question for the Q&A panel that is going to follow after our presentation, because these do prepare something similar to vetting, but it's not sure which way to move. So basically, it's inviting opinions. Herman here, Georgie, Greg will be there on the ground in Skopje, and they will be more involved into this. So basically, we shall see how the government will react. Catastrophically, I mean, having known the Macedonian government. So basically, yeah. First of all, it's back to my presentation. It's an honor to be invited. The Democracy Index Georgia is really on the forefront for spearheading any policy recommendations in Georgia and addressing any hot topics for the Georgian judiciary. Starting from judicial ethics, I see Jim in the audience. Jim, it's a pleasure. And from to judicial vetting and alternatives to judicial vetting, and especially in such turbulent times, such as currently as is in Georgia. So, as everybody know, last year we the group of experts led by the Sila Institute, we have tried to in some way codify everything there is about judicial vetting. The judicial vetting is an instrument which is not envisaged in international judicial documents. It's not envisaged as a standard for accountability of judges, but it has been suggested by the European Commission as a tool for cleaning the judiciary, or cleaning the bad actors from the judiciary, to be more precise. And that tool, it's used in former socialist countries, which are struggling with problems of a judiciary, whose judiciaries are in the report detected as captured, or the judges are the judges have it's a judicial corporatism or self-interest, serving their self-interests. So basically, this vetting process started in Albania, then it spread to Ukraine and Moldova, how we may know. It's also applicable jurisprudence of the European Court of Human Rights regarding the vetting in Albania. We'll get to that later. However, it was also it's an instrument which is used for judicial accountability, overhaul of the entire judiciary, but also. And this is how you know that it is a positive instrument. One of the documents and one of the public releases from the Kremlin following the invasion of Ukraine was that the Ukrainian judiciary is being overhauled by Western experts with something which is called vetting. I've noted this in my presentations. I will send you the document. So basically, if the Kremlin says it's bad, then it's good. In summary. That's how the story of vetting ensued in Eastern and Southeastern Europe. And this group of experts tried to codify all the documents issued by the Venice Commission and all the decisions issued by the European Court of Human Rights, to codify, to get a knowledge of what is vetting. So basically, vetting was, as you know, it's divided into three parts. First is pre-vetting of candidates for Judicial Council and Council of Public Prosecutors, and pre-vetting of the sitting members. That is the first step of vetting. So basically, if there is a vetting of members of Judicial Council and Councils of Prosecutors, then constitutional changes and reforms must follow suit. If only candidates are involved, then no constitutional changes are needed. The second brand of vetting is security vetting, which was used in Croatia, but unsuccessfully, in Slovakia. Unsuccessfully, I'm saying because it involved members of the security services being present in appointment and dismissal processes of judges. Basically, it ensued problems with storing of judicial data, and creating and crafting questionnaires which were filled with very personal questions, such as the sexual orientation of a judge, question that has nothing to do with performance of the judicial function. And these laws promulgated in Slovakia and Croatia, usually they were amendments on the law on Judicial Council and the law on courts, ensued that the Ministry of Justice will be the mediator in the appeal procedure with the judges and the Supreme Court, which was the second instance organ. And also these laws failed to include mechanisms for the willing to decline to undergo such a security clearance, such a security check, which is, of course, against the jurisprudence of the European Court of Human Rights, established in the case of Tanza versus Albania and established in the case of Taxicat versus Belgium. And such mechanisms not only were declared unconstitutional by the Supreme Courts of Slovakia and Croatia, but also they were declared very dangerous by the Venice Commission themselves. And the third type of vetting is something we saw in Albania, and we are seeing currently in Moldova, which Herman will talk more in detail. Well, Albania was the guinea pig, so to say, because the entire vetting process started there. That means the overhaul of the entire judiciary, the Judicial Council, the Council of Public Prosecutors, and every serving judge and prosecutor and legal advisor to the court. The vetting criteria is checking the financial implication of the members of the judiciary, which go back to 10 years of period, paying taxes, financial regulations in order, financial backstory and checkups should be in order, integrity checks, meaning the judges are not being members of a religious or political association, nor have been any association between members of the judge's family or extended family to be members and active members of political association. And also the integrity check included the quality of the judicial decision ensued to detect whether or not there were any conflict of interest between the judge and third interesting part is the case of the European Court of Human Rights exploring this issue is Georgia versus Albania. I'll send all these cases, my dear colleagues, but also they are briefly elaborated in the guidelines of judicial vetting, which is I will also share with you and I will share with Keta, where you will find more information about these vetting proceedings. So basically now this is the vetting proceedings, and these proceedings are requiring constitutional amendments, which we all know are a nightmare. We need political bipartisanship in parliament in order to push for constitutional changes. Why? Because for example, members and the position of the judicial councils are enshrined in the constitutions. And if you are introducing some mechanisms for extraordinary checks about those members and the Judicial Council themselves, then it must be fulfilled principle of legality. And principle of legality must lead to constitutional changes. Next step, you need a law who will detail all the proceedings created from the Constitution and to establish the rules of the game. What commission will be responsible for monitoring of that process, and what commission will be responsible for conducting the vetting processes or pre-vetting processes. Usually those kind of commissions are in our findings, they are created in parity composition. Parity means half of the commission members are international experts delegated by the European Commission or United States. And part of the experts are domestic experts, which are delegated by the national authorities, usually meaning people who enjoy big reputation and very good legal reputation within the system. And of course, Herman knows, being member of such commission, they enjoy certain immunity in their decision. They enjoy fact-finding opportunities and responsibilities, and of course those commissions, if you're having any questions in mind whether or not they're legal or whether or not it is some sort of foreign interference into domestic states, they're not. Analysis of the OSCE and ODIHR have confirmed also that such commissions fulfill the criteria for impartial and independent tribunal within the Article 6 of the European Court of Human Rights. And such commissions are of a temporary nature. If it's in the Constitution, it must have a clear defined aim and clear defined nature and a period, a mandate. So basically, it's temporary and it's an anti-corruption. Oh, and of course, for these vetting processes, the critic can say, oh, vetting is just another form of lustration, or vetting is just another form of, like everybody here remembers the lustration period in the post-Soviet, post-socialistic republics, which was very hard to say, unsavory process. Even it was legalized by the Parliamentary Assembly of Council of Europe. But the difference between lustration and vetting is that lustration is pertaining to human rights abuses during the socialist period, and vetting is anti-corruptive targeted measure to rid out corruption within the judiciary, and that is how the Venice Commission is seeing vetting. And alternatives to vetting is a new topic, which is this year, the beginning of 2024, started to be popular in legal circles and judicial circles around Europe. Alternatives to vetting is avoiding the vetting mechanisms in itself. It is my pleasure to announce here that the Silly Institute, a core group of judges is already working on another guidelines on enhancing judicial accountability, which will include a section about alternatives to judicial vetting. So basically, we are exploring the judicial alternative vetting practices on how you can improve the judiciary without entering the vetting process in itself. The members of the editorial board, through various discussions, have included the pre-vetting mechanisms are suitable as an alternatives to vetting. Why? For example, in Georgia, there were two reports last year, one issued in October and the second one issued in November. Please correct me if I'm making mistakes with the dates. But the nature of those reports from the European Commission was to explore any mechanisms for extraordinary integrity checks of judges in Georgia, and the reason why such recommendation was given it was to address judicial corporatism within the judiciary and self-interest of judges. So, because we are all lawyers here, and there is no the recommendation explicitly directed that we should that the Georgian authorities should address judicial corporatism not within the judiciary itself, but all to the governing bodies of the judiciary, the High Judicial Council and the High Prosecutorial Council, not within the entire judiciary itself. Why is that? And this is an alternative to vetting where they come into place. Accountability of judges as an instrument is already known in the international and European standards. European standards, which Georgia is part of, as well as North Macedonia and all other countries. Those standards are enshrined within the decisions of the Venice Commission, the Consultative Council of European Judges, Consultative Council of European Prosecutors, and the decisions of the European Court of Human Rights. Alternative to vetting imply vetting only the candidates for the High Judicial Council and Council of Public Prosecutors. That is the first alternative. The second alternative, it is to establish monitoring mechanisms to appointment and dismissal processes of judges, which means to open up the institutions. The Judicial Council are responsible for disciplinary proceedings. This means the discipline first must be some very well thought of criteria for disciplinary proceeding to prevent arbitrariness, and also to enforce and establish transparency into those proceedings. According to the newly published OSCE, it was end of last year, of course, Warsaw recommendations, dialogues, so more transparent proceedings, dialogues with government and strong judicial associations. That means that dialogues with government means that judges and public prosecutors must have a strong lobby. According to the international documents, they have judicial associations and prosecutorial association. That's opinion number 24 of the Consultative Council of European Judges, which means those associations must have a proactive role in representing the interest of judges, of the judiciary and the public prosecution into negotiations with the government and full collaboration with the NGO sector. That means that all problems pertaining judiciary, starting from financial independence, which is a problem we see in North Macedonia and the countries of Western Balkans, especially in Croatia, we saw it last year, from financial independence to ethical standards, disciplinary sanctions, and of course the transparency into the proceedings. The third alternative is so strong judicial association dialogue with the government is the second. The third alternative to judicial vetting is public engagements. The public engagements is something which experts from the Venice Commission are referring to the monitoring provisions in the law on judicial councils. You know how the law on judicial councils have monitoring provisions about the work of judges and presidents of courts. and measuring criteria, objective and subjective measuring criteria of the work of judges. And that criteria is being basically used by the legislator whether or not to put a stranglehold on judges, on judiciary as a whole, or to ease up judiciary as a whole. Currently, it's being weaponized, so to speak, depending on the government. And this standard, according to the Venice Commission, is implying that the measuring criteria and monitoring criteria must be in line of the judiciary, must be in line with the, as they put it, the reasonable standard of the viewpoint of the judge. Means that the judge is not a robot, and the judge cannot be overburdened by cases to convert them in some version of ChatGPT to issue decisions on merit basis. No. This means that you must unburden the courts and bring more judges if there is a backlog of cases, so the judge can have a time to take a decision one case at a time. This is a problem I found it in doing another research study this year about the role of lay judges. It was for the European Union in North Macedonia. And one of the standards I have discovered about the role of lay judges is there is no monitoring mechanisms for lay judges. Countries just, they don't prescribe monitoring mechanisms. And in criminal cases, when a lay judge goes missing, there is no accountability for it. And the case starts all over again. And guess who takes the blame? The court, of course. The courts take the blame because the public doesn't know anything, why the cases is restarted. The public doesn't know the measuring criteria. And as Georgie said, we have a problem with public engagements. Yes, we do have a problem with the public engagements. The public doesn't recognize what is a jail and what is a prison. And we expect them to understand monitoring mechanisms of the judicial disciplinary proceedings. So basically, the work of the courts and the work of these judicial self-governing bodies through public engagements is to explain to the public this work, to explain to the public how their judiciary work, because the judges and these bodies are serving for public interests, and the public has the right to know. And the fourth standards we're currently working on, it will be in detailed. It's still under construction here. We're still gathering resources. It is the clear standards for confirmation hearings. It means when there is a judicial appointment, whether it's a member of the Judicial Council or a member of the judiciary, his or hers examination must be public. The public or streamed online, so the public can participate and see what kind of a member of the Judicial Council is the council electing or parliament electing, depending on the legislation. So this is something similar what we see in the US in judges' confirmation hearings, where the judge is asked questions through members of the legislator, of the members of the Judicial Council. The judge is asked questions about their positions in key societal cases. For example, what is your stance on ecology? What is your stance on crime? What is your stance on women reproductive rights? And so on and so forth. And such confirmation hearings have been suggested as an instrument for bolstering the transparency and accountability of the judicial councils. So to sum up, ladies and gentlemen, the alternatives to vetting are mechanisms which will offer offers reforming of the judiciary and enhancing the judiciary in a country without entering into full-fledged vetting processes, without amending the constitution or appointing a commission or international commission, by increasing the value of the current processes we have into the laws, and we increase the value and output of those processes to increase transparency in dismissal and appointing procedure of judges, to increase accountability in ethical standards criteria. We must know when the judges are responsible and how the proceedings are going into practice, what kind of procedural rights the judges in disciplinary proceedings have. And of course, the selection of members of the Judicial Council and Council of Public Prosecutors must be done publicly and must be done under the scrutiny of the NGO sector and the general public, because, of course, they serve at their interest. And with this, I will end my presentation, and I am at your disposal for any questions ensuing into the debates. And my friend Herman, you will hear it from the horse's mouth, so to speak, about all the problems faced in Moldova with the pre-vetting commission and the legality of such commissions with the establishment and the entire functioning process. Thank you very much.
Thank you very much, Andrei. It is always best opportunity to listen to the expert about this new mechanism who is just working on these guidelines, which is supported by Silly Institute. And thank you so much. I think that we have a lot of questions to you. I have them a lot, but I will leave it after in the end of our discussion. I see that our expert from Georgia, Guram Imnadze, is also joined our discussion. But before he will talk about our reality in Georgia, I think that we will pass our floor to Herman. And in the end, Guram will, of course, share his experience as an expert about Georgian judiciary, and also we will hear and listen the recommendation from our experts, what is better for our judiciary, how we can achieve success is vetting or alternatives of vetting, which is better for Georgian reality, even we don't have any political will now. So I'm passing the floor to Herman, and with pleasure we will listen to him.
Right. Thank you very much, Kata, and thanks for the invitation to join you today on this discussion. And of course, for me, it is to a certain extent easier after having listened to Georgi and Andrei to pick up on the issues, but also then to refer back to what they said. And I think what Georgi started off with, which I think is incredibly important, is that whatever we discuss, it's all about trust in the judiciary. And we all recognize that in many countries, the public trust in judiciary is low. They've seen figures about Macedonia being extremely low a couple of years ago. And, coming from a country, the Netherlands, where the trust, thankfully, is extremely high in the 80s, 85, 87% and whatever. At the same time, also, I see that you can never sort of lean back and just watch, everything is in good shape. The trust in the judiciary, and that is both for the public but also for the judges, is actually a constant battle. It never stops. And that also means that in each and every country, there are a variety of measures possible in order to increase that trust. And that's indeed where I can share some of my experiences with my work for the Pre-Vetting Commission in Moldova. But at in the meantime, I've been moving on to Macedonia and working with the Judicial Council over there on a couple of alternatives. So I'm taking the liberty to look at a number of those aspects and also thereby to create an overview of the kind of alternatives that are possible in that respect. But indeed, vetting and pre-vetting, Andrei already explained a number of aspects of the differences there. And having worked and still working on the almost finalization of the work of the Pre-Vetting Commission in Moldova, what I think is very important to take into consideration is that pre-vetting is a much less sort of intrusive system than vetting is. The legal consequences of a process of vetting is that in case a judge or a prosecutor does not pass that vetting, that also means the end of his or her career as a judge or as a prosecutor. Basically, that person is out of the system. With pre-vetting, that is not the situation. Pre-vetting, in the way it was done in Moldova, is that judges and prosecutors who are interested to become eligible and to be elected as a member of the Judicial Council, the Prosecutorial Council, have to go through this screening process, this pre-vetting process. And as a result of that, if a person fails that evaluation, then the person can no longer be eligible, but at the same time will be able to continue to work as a judge or a prosecutor in his or her position. Of course, that can also lead to discussions in the public because, hey, if a judge does not pass the evaluation and there are some serious, ethical or financial issues, how can you justify that a person can continue to work as a judge or a prosecutor? So it's not a black and white distinction here. But I think what you need to keep in mind, what I think is very important is that, these kind of mechanism of pre-vetting or vetting is not something that every time there are elections in the country that a new government can say, oh, let's do a process of vetting or pre-vetting, and thereby, basically taking the a number of characters from who are close to the previous government out and put their new puppets into that system. That is something that should be avoided under all circumstances. These kind of mechanisms, pre-vetting or vetting, are one-off exercises that should last for a very long time, that should be thorough, that should, and also Andre already referred to that, have to be completely in conformity with the principles and the jurisprudence of the European Court of Human Rights on Article 6. And also in our decisions that we have taken, we spend an enormous amount of time and effort in the analysis of what Strasbourg case law does imply and what it means for the way that we have done our work. But again, what is very important to stress is it has to be a one-off exercise. It's not a toy for any new government to play around and to replace a judicial council or to replace judges in the Supreme Court or the Constitutional Court or whatever. This should be, that would undermine the independence and impartiality even more. And I bet that also the public would not trust such processes. Pre-vetting then, we have done a number of, I think, close to about 70 cases of judges and prosecutors. Unfortunately, I must say more than half of them did not pass the evaluation. That has to do partly with the fact that a number of candidates did not withdrew from the process. Sometimes after we came up with very critical questions that they thought, oops, I'm not sure I can answer those questions, so let me better get out of here and withdraw from that process, but also in a number of cases simply because of the fact that we identified a number of serious issues where, inexplicable financial situations came up. How can a judge that has a salary, unfortunately, in many countries, as you know, the salaries of judges and prosecutors are extremely low. How can you have a low salary and drive around in a very big car or have a huge house that costs so much more than any decent salary can explain, and of course it may be that you have a rich father and mother or father and mother-in-law, which is not a crime, obviously, and there can be explanations for that. But the whole pre-vetting exercise was focused on asking questions, raising doubts, and then for the candidate to identify arguments which show that our concerns were adequately addressed. But also ethical issues that have come across. But we have always been, and that I think is very important to emphasize, we've always been trying to stay as much as possible away from the work of a judge in a particular case. We were not a commission that dealt with the quality of judgments and the quality of prosecutors. Only in exceptional circumstances did we look into that. But we were not a third or fourth instance mechanism. We were not looking into the quality of the judgments. We were purely looking at the financial and ethical integrity of judges and prosecutors. The process and the Moldova experience also shows that the cleaning up of a judiciary and prosecution is incredibly complicated. We did take a lot of decisions in first instance, and what we call our initial evaluation decisions. Candidates were entitled to appeal that decision to the Supreme Court of Justice. The Supreme Court of Justice was not yet cleaned up through our process. And what happened was that a huge number of our decisions were overturned and were annulled by the Supreme Court of Justice. And so we had to do our work again. 2 of the 3 members of that panel of the Supreme Court decided to withdraw and to walk out of the judiciary a few days after their decisions, because they knew, oops, now they will come into a system of evaluation as well. And apparently they already recognized that it would be difficult for them to pass that evaluation. So they took the decisions, they threw a lot of those cases back at us. And at the same time, a few days later, they walked out of the judiciary themselves. And it shows that, if you see that there is an issue of trust and integrity problems with the judiciary, the question is where to start and how to do that. And there is no ideal situation for, there's not a one-way solution for all situations. But I think in the meantime, we have seen that other commissions in Moldova have picked up on the vetting of judges and prosecutors. My experience, and also based on what I've seen, for example, in Albania, is that these processes are disruptive to the system. Certainly when you talk about vetting and when you talk about the legal consequences that a judge or a prosecutor has to leave the system. As we have seen in Albania, the process takes extremely long. Many judges are being thrown out. And it also means that the remaining judges are, confronted with a huge backlog in cases, which in itself is also not good for the trust of the people in the judiciary. So it's a sort of catch-22 situation. I think the more and more I think about those processes, I think it is necessary in every form of pre-vetting or vetting that you always look at a limited number of people that are going through that process, and that you look at leadership positions, and that once the leadership is clean, then they can the clean leadership can actually take care of the cleaning up of the rest, So, and I think what you need to do is indeed do a focus on pre-vetting or vetting of the Judicial Council, a prosecutorial council, a Supreme Court, probably the president and vice president of courts of appeal, maybe all judges of the courts of appeal, and the president and vice president of the courts of first instance. Once you have done that, and once you have come with clean results, then they have a strong enough self-cleaning mechanism that they can apply to the rest of the system. I think it is wise to avoid a situation like in Albania, where the process goes on for years and years, and that, as we see, leads to a diminished trust in the entire process. It needs to be done as fast as possible, also for the candidates, because of course there's a lot of insecurity for them, as fast as possible, but also as careful as possible, because again, Article 6 of the European Convention does apply to such procedures, and it really leads to a lot of requirements to do it in the right way. But then I think the question of the quality of the judiciary or the prosecution system is about more than pre-vetting and vetting. And I like, again, what you said as well about issues of adequate resources. I think we can say of every single country as part of the European Council of Europe that every country we recognize that an amount of resources being spent on the judiciary, on the prosecution, is not enough. That's not enough in Macedonia. That's not enough in Georgia, I bet. There's not enough in the Netherlands. I'm always complaining, and I see that my association of judges in Holland are complaining out the fact that there is insufficient resources. It's always a question of not enough resources, but knowing that that is a situation, there is also an obligation for the Judicial Council, for the Prosecutorial Council, if they have a budget that is really their own, and of course in Macedonia that is not the case, that budget, that every single penny is used in the most efficient way. So it's not only about the total amount of money that is available, but also about how do you spend that money in the most efficient way. And Georgi, you mentioned already that, you see a lot of, there's a huge number of courts in the country. Do you need all those courts, especially if you have very small courts with only 1 or 2 or 3 judges? How can they deal with a variety of cases? Is that really justice delivered at the best level? Let us think about those kind of issues as well, and maybe come with some merger of small courts or whatever. There are examples in Albania and other countries as well. In Holland, it was done some 10 years ago as well. These are difficult processes, but I think the judiciary and the prosecutions also owe it to themselves to do it in the most effective way. And then the last comment I would like to make, and that is related to the issue of disciplinary procedures. At the moment, I'm working with the council in Macedonia. And of course, also part of the conference that we will have next week in Macedonia and processes afterwards about how to make disciplinary procedures for judges as up to international standards. There's a huge number of Strasbourg decisions about that. SEPESH is developing a new recommendation on this that is coming out in the next month, I think. And these are good guidances on how disciplinary procedures can take place and how they can be transparent. I think public hearings is, a very important one, which is not the case in Macedonia, but I think it is something that we need to discuss there, because that is how the public and also a person subject to such procedures knows that the process will be fair, because everyone can follow those proceedings. But that is work in progress, but it's part of it, and we've seen also in Macedonia recent cases of disciplinary procedures where it was abundantly clear that there were serious problems with a particular judge, which had to lead to a dismissal of a judge as well. But these kind of things, they of course have a huge impact on the trust of people in the judiciary if they see these kind of cases, and therefore disciplinary procedures are necessary. But of course, they focus on individual judges or prosecutors only. And of course, vetting and pre-vetting are more of a systematic overall nature. Disciplinary is more a one-on-one issue, an individual process. But they can strengthen each other. One does not exclude the other. And again, it all comes down to the issue of trust. Let me wrap up over here, Kata, and thanks very much again for this invitation. And of course, like all other speakers, happy to answer any questions that you may have. Thanks very much.
Thank you so much, Herman. As always, your speech was great and interesting and fruitful. And thank you again for joining and to be the part of this discussion. What I would say, and it is very important, that even if vetting has some negative sides, that somehow the judiciary for the time is left without some judges, and there are a lot of problems. Even as in different countries, also in Georgia's judiciary, despite the reforms which was conducted during the years, we could not achieve the independence and accountability of judiciary. Still, allegations of corruption remains, and Council of Justice is a pillar of a clan-based rule of court system. Is a very big problem again, and it seems that unless the judicial personnel are selected on merits, and as you know that most of judges are now appointed for lifetime in Georgia. That means that the vetting is the best solution now for our situation. On this topic, I think Guru will speak more detailed and share the situation in judiciary now. Where is Georgia's judiciary now? How we overcome our obstacles and our problems, and I will leave space to Guru and pass the floor to him. And I think that for our experts, it will be also interesting because they are supporting us and they really care about our judiciary and our democracy democracy in Georgia. And I think that after Guro's presentation, they could also have a more clear understanding what needs now our Georgian judiciary for success. Please, Guro.
Thank you, Keta. Good evening. Apologies for joining you slightly lately. And thanks to organizers for inviting me into this discussion. I'll speak about the prospects of the vetting in Georgia, not the vetting, because I'm pretty sure you are well aware about the outcomes of the recent elections. And I guess now is the best time to discuss the prospects of the vetting, all the possible alternatives, and all the experiences, relevant experiences about this vetting. And summary document Andrei mentioned would be really crucial, and codified document would be really helpful in that regard, because this is kind of novel environment in Georgia, and I guess not for only Georgia. But briefly, I will speak about the overall situation in Georgia and why we came into this environment when the European Commission issued recommendations about the vetting process. I will not go deep into the historical development of Georgian judiciary, but briefly sum up some key areas of the reforms. First of all, since 2012, we have this kind of illusionary shift from political appointments to professional appointments, when High Council of Justice gained all the appointing powers in lower instances, and in Supreme Court, High Council of Justice has nominating power. And also here comes lifelong tenures of judges, which was introduced in order to increase individual guarantees of judges. But these changes has not came together with fixing problems who holds power to implement appoint judges. I mean, High Council of Justice. High Council of Justice has not experienced systematic reforms. All the reforms in the council was, I would say, facade. Has facade nature, and that's why all the key decisions regarding appointments, regarding promotions, etc., by the council was led was made but not based on merits, but based on chronism and political interests. By the way, we have quite recent decision from European Court of Human Rights about Georgia, about appointments of judges. The case was about Maya Bakradze. I guess she is with us in this discussion also. Maya is a former judge. She wasn't appointed during 2015-2016, and the European Court found violation of her rights, freedom of expression and freedom of unity, because her interviews during this competition in the High Council of Justice was led in such a nature that the council was not interested about Maya's professional capacities, qualification, or integrity, but her side activities as a member of the then existed group, unity of judges, which was quite critical association about Georgian judiciary, and Maya had a leading role in that professional association, and all the majority of questions during her interview was aimed about her activities, her public positioning as a member of the unity of judges. And Maya, regrettably, Maya was not the only judge who was refused to be reappointed at that times. Quite contrary, she was one of the many other critical, maybe independent judges who were not appointed because they were considered as, how can I say, dangerous for elite group of judges. So since 2013-14 or after 15 especially, we have this situation when judges in the system weren't appointed based on the merits, based on their professional achievements and capacities or integrity, but their loyalty to either political elite or with this influential group of judges. And then we have, of course, kind of monstrous institution such as High Council of Justice, which holds all the powers to make decisions on almost everything happening in the judiciary. And we have right now increased consensus within the judiciary right now that everything is perfect, everything is going on a right track, because there is no dissenting opinion, or almost no dissenting opinion within the system. And all we hear from the justice sector currently, from the corpus of judges, we listening that everything is going perfectly. Now that some ratings, some rankings are pointing out that all these reforms we've been experiencing has positive impacts. And outside of the court system is also increasing consensus that nothing is going on the right track, and everything is quite problematic. That includes in Georgian civil society, professional groups, and also outside. And that's why it was this kind of increased consensus resulted in recommendations from the High Council of from the European Commission that may be the only effective tool to tackle all these challenges we are experiencing is vetting. So now we have chronism, enhanced chronism in the system, but it's not a kind of independent problem that is framed, or that is limited through the judiciary system only. Of course, it has political dimension, and to say in other words, political demand, political influence resulted or created this kind of tensions and situation in the system. All this we quite often we are mentioning in influential group of judges or clan of judges. This group currently exists because the only reason they are existing is that it was the political will, it was the political demand, and political government, political party, okay, we can call them ruling party, did everything to strengthen this group, to enhance their influence over the whole justice sector. But once again, we have not been mistaken, because this political influence is not visible on everyday justice cases, on ordinary cases quite often. And that's why statistics, for example, acquittal rates are showing that we have improved results in, for example, acquittals. If we compare this number to the numbers we had before 2012, for instance. Now, some rankings are also improving, some really, how can I say, in international, well-written and with perfect methodological framed rankings are also showing that some parameters in Georgian judiciary is improving. But the only explanation is that current political influence over the justice sector is used more targeted, more strategically, more selective, and that's why all these key problems aren't visible or easy to notice in everyday justice cases. But for example, if we took at cases related to the election results, and it's visible that all decisions are made based on political influence, political interests, and there are no actual decisions on elections which is following of standards of rule of law, etc. They are totally based on political demands and political orders. So that's why we have this kind of situation. And last problem, of course, is lack of accountability, which also strengthens this chronism and political politicization, of political instrumentalization of the justice sector. We I cannot name any legal formal instrument of accountability which is effectively working currently. Even the basic public information requested from the High Council of Justice, for example, isn't accessible for citizens, for research organizations, watchdog organizations. Court decisions are not open, accessible, neither. So yes, that's why the system is closed and there is no accountability at all, almost. With this context, we came into the vetting recommendation to cite this European Commission's recommendation. There is written that Georgia needs to establish a system of extraordinary integrity checks with the involvement of international experts with a decisive role in the process for candidates and persons currently appointed to all leading positions in the judiciary, in particular the High Council of Justice, the Supreme Court, and court presidents. So this recommendation is quite targeted, I would say so. It doesn't say that this mechanism should be aimed at all judges or majority of judges. Quite contrary, around 15 or 20% of judges will be targeted if this kind of, with this frame, voting will be introduced in Georgia. And it doesn't say anything about prosecutor's office. The European Commission's reports are saying that prosecutor's office should also be reformed and should be under systematic reforms, but prosecutorial council does not enjoy with quite comprehensive or strong influence and power legal tools in Georgia. That's why this institution doesn't play crucial role on prosecutor's office work. So only changing rules of appointments of prosecutor general would have a significant impact, because this position has decisive role in whole system of prosecutor's office. To get back on prosecutor's office, on the judiciary and vetting recommendations on the judiciary. We, Georgian civil society, had extensive discussions about this particular issue. How should be considered and perceived this recommendation and vetting tool itself? Is it kind of last resort tool, or is it the only effective tool currently we could use? Of course, we acknowledge all these risks and problems connected to the vetting, and all these experiences which are not quite optimistic on previous vetting experiences or on other countries with more or less similar experiences. But when we are thinking about other options of the chain vetting, alternatives of the vetting, first of all, we have to answer to the question: why do we need this kind of mechanism? What problems should be tackled with this mechanism? And as I mentioned, and my colleagues also, we have lifelong tenures, and we have judges in the Supreme Court, for example, appointed for lifelong tenures. We have court system, corpus of judges, where majority of judges are not loyal, openly loyal, but they are somehow compromised, and they might be easily manipulated by this influential group of judges. So High Council of Justice is under the heavy control of this influential group of judges. So these two key institutions, the one of them is judicial instrument, Supreme Court, which might have actual influence on all cases. And even if the lower cases, there are some improvements with court packing, with appointing new judges, etc. Supreme Court can change all key decisions and can get back on problematic decisions. On an administrative level, High Council of Justice, once again, is under the heavy influence and heavy control of the influential group of judges of the clan. And that's why common tools such as disciplinary proceedings or ordinary tools such as disciplinary proceedings or even prosecution. We are not sure that these kind of instruments could be effective in order to tackle systematically problems we are facing currently. But of course, vetting should be considered as a tool of transitional justice, and it also should be part of the bigger approach. We do not see these mechanisms as the only wholesome solution, which would be enough to deal with all the problems we are experiencing. It should be part of the bigger problem, part of the bigger approach, bigger program of systematic reforms, which could cover, of course, appointing and promotion rules, which covers, of course, reforming of the High Council of Justice itself, how should be staffed this institution, what should be powers, and how should be decentralized, deconcentralized powers of High Council of Justice, how should be further strengthened individual independence and guarantees of judges. For example, transferring judges from one court to another, disciplinary mechanisms, etc. But it should be these institutional and legal reforms, and vetting itself should be kind of complementary instruments to one another. Otherwise, in Georgian case, which is quite, I would say so, unique, we could not find two alternatives than this particular mechanism. But of course, now is the perfect time to discuss all the possible scenarios, and that's why I'm really thankful. We are really thankful for all these discussions, cycles of discussions, and these evening discussions, in order to quite critically assess, analyze all our opinions, because now is the time to think about ideas and reforms, because this window of opportunity will not be long for actual reforms, because we know even from the Georgia's experience that if there is no decisive actions made by the civil society and the political decision makers, then all the governments have this kind of weakness to spread its control over the judiciary. And the same happened in 2012-13 in Georgia, when there was not decisive steps made by the Georgian Dream, and after that they also got into negotiations with the judiciary. Thank you once again, and I'll be also happy to answer all the questions.
Thank you so much, Guram, for sharing your experience. I think that now it's more clear how much Georgian judiciary is in problems and faces obstacles. I will just add that before, like 3-4 months before this law was introduced of transparency of foreign influence in Parliament and was adopted, the vetting and this European Commission's recommendation, one of the top topic in society, in civil society and in judiciary, on which we were gathering, negotiating, and really it was very important time for us. But the situation, what happened now, what is happening now also in Georgia, like we have absolutely different reality, but still we think that the importance of these meetings and discussions, and to have really exact solution about what is better, the vetting, alternatives of vetting, or some other tools for judiciary. I think it is very important, and even this is the relevant time for discussing and have this expertise from professionals. So now I will go to the question and answers part, but I will ask to every participants have just one question, because we have very few time, and I will just pass our agenda 10, maximum 15 minutes. So please raise the hands, and our experts will answer your questions. And The floor is open. Of course, I see Kaha has a question. Please.
Hello, everybody.
Kaha, I will just add that if anyone wants to ask question on Georgian, we have interpreter and he will translate, and so it's no problem. You can ask question on Georgian also.
Hello, everybody. Thank you very much for excellent presentations. There's always a necessity for sharing experience, because there is always necessity to compare our experiences and find out what is common, where is the common problem, and where is the separate, where are the differences, because the common problems may have common solutions and different problems may have different solutions. Basically, I will just make a few comments and just make one question. The comments about the Georgian judiciary, I think they are quite different. They are somehow quite different from Macedonian experience and from Moldova experience, because in case of Georgia, we have only one group of judges who are dominating a system, and they have created a little family, and there are rules, there are informal rules in the family. So if you want to be appointed, you have to comply with these rules. If you want to be promoted, you have to comply with the rules. And what are the rules? The rule is that you have to bring your contribution to the family. It's like there is a contribution that you have to bring to the family. And what can be the contribution? The contribution can be that you gather votes for judicial elections, that you make a decision on a political case in favor of the government. So there are different types of contributions that you should bring to the family, and then you will be appointed, and then you will be promoted, and you will be appointed in the Supreme Court, and so on. I think there's an informal structure inside the judiciary, which looks like a big family, because they inside they want to make a spirit of a family, so everybody belongs to the same family, and so there's no formal procedures. There are just informal rules which matter. So basically, one question that I have was that how is going to be possible to fight against such a structure, to change such a structure in the future by way of vetting, for example, Let's take one example. There are different examples of judges, and they were asked to take a decision on a political case, and they were before the expiration of their time, before the expiration of a mandate. And they were told that if you take a decision on this case favorable to the Georgian dream, then we are going to reappoint you. And now the judges took political decisions, and they were promoted. They were appointed to the Supreme Court. Now, what do we have? We have a decision which is biased, and where you can see that the judge was biased. Where if you read that decision, you may see that the judge was biased, but it's difficult to prove or to bring any witnesses of any influence or of any interference, because it's a clan, it's a mafia, and they don't talk. They never talk, basically. But we have a decision which is clearly biased. So the question is, if there is a judicial vetting in Georgia, is it possible to make any judgment based on biased decisions made by the judges, particularly on the political cases? So that was my question.
Okay, Andrei will answer this question. Please, Andrei.
Thank you so much, Kaka. Very on-point question, so to say. Let me just say that this is written in the guidelines on judicial vetting we have published. The Seal Institute published. It first says that you must be aware of the steps that you are making about the vetting of a country. It's not about one judge. It's about the people who are appointing judges into the judiciary. So basically, in order for a vetting to occur in a country, first the national authorities, I mean, of course, with the help of the, sorry, with the help of the European Commission, they must provide a country scale analysis on the effectiveness of the judiciary, country scale analysis of the effectiveness of the Judicial Council and Council of Public Prosecutors. And first, before doing that, they must consider alternative measures before vetting. That means before considering extraordinary vetting, consider using existing or alternative options, such as addressing weaknesses in administration of justice, improve integrity and ethical standards of the member of judiciary, enhance professionalism through judiciary continuous education of the members of judiciary, and address alleged corruption among the members of the judiciary. Based on the presentation by Guram, what gave us, and I didn't know we had a European Court of Human Rights star, Judge Maya Bakradze here. Have you noticed, have you ever noticed similar cases like hers are Harabin versus Slovakia, Baka versus Hungary, and Olujic versus Croatia? All those cases have problems with judicial appointing proceedings of the Judicial Council. And it is the Article 6 and Article 10 which are infringed into those cases. So basically that tells me that that judicial councils, which is the mechanisms for appointing judges, vetting could identify bias and conflicts of interest and ensure judicial council members are committed to fair standards and not influenced by personal, political, or in this case, retaliatory interests, ensure transparency and accountability, and of course, for the purpose of protecting judicial independence. And also, when regarding political decisions, there's only criminal law, criminal trials, and civil trials. There are no political trials. I mean, so far, the mechanisms are in understanding. Thank you.
I see Herman, yes, want to comment.
Yeah, just very briefly, I think it's a very interesting question indeed, and I just wanted to say that in our cases in the pre-vetting commission, we actually had a few of those instances as you just described, where indeed a president of a court submitted cases to a particular judge, also with the indication, and there were notes. The president was a bit sloppy. There were notes found in his drawer which cases were going to a particular judge and what the outcome was expected to be from the decision to be taken. You know, these kind of cases, of course, are very, very strong indications, and you can imagine what the outcome of that decision was. So no surprise there. But of course, this would also, in case of an investigation, if these kind of things, you know, were to come up, this would also obviously be a case for a disciplinary procedure. But then, of course, the question is, what is the strength of the disciplinary procedure in the country? And of course, I don't know. You would know better than I do. But of course, that's where you come into sort of vicious circle. What's the quality of those kind of procedures in order to address those concerns? But yeah, to answer your question, it has been coming up in a number of our decisions. So it certainly is a very valid issue, and pre-vetting or vetting may assist in identifying those problems. Yeah. Thank you. Yeah.
Thank you.
If there is some other questions,
maybe may I? Good evening, everyone. It's very nice to see everybody. So
thank you.
აია, შენ გინდა რამის თქმა?
პატარა კითხვა მაქვს ერთი, მაგრამ ეკას მე რჩემილია.
Go ahead, Maya.
ცუდად იჭერს ინტერნეტი. Thank you. Good evening, everybody. Thank you to our brilliant speakers for interesting speeches. I have short questions. Maybe anybody of you knows that whether there is some assessment or report evaluating ongoing or post-vetting process in some countries, I mean Eastern European countries. If there is any, please send it to us if anybody knows about it.
I'm just going to say this. Yes, there are reports, Judge Bakradze, there are reports. especially in the Albanian position, were very well written. Some of those reports are cited into the guidelines on judicial vetting, which we published. Those reports refer to the actual state of affairs of the judiciary before and after vetting, and the success rate between this vetting. Unfortunately, there is a successful. I mean, that report is not published yet. That data to us was given by the Judge Mischenko, Supreme Court Justice Mischenko, who is leading the judicial vetting in Ukraine. He gave us the statistics of his commission, on pre-vetting commission on candidates for judicial council and council of public prosecutors. Those statistics are from last year, and they describe how all the vetting of judges, all the questions before the vetting commission are streamed on YouTube. So basically you can find them. And also you can find Herman Commission, which he leads in Moldova, on YouTube. So you can see what kind of questions Herman and his team are asking to judges. I mean, Herman, you can elaborate something more in detail on this, but I believe YouTube is a very good, place to gather information, so to speak.
Yeah, very briefly. Yeah, that's correct. On the pre-vetting commission, if you Google pre-vetting commission Moldova, you automatically get to our website. We did stream all the public hearings that we had with candidates. So we had a process of first identifying information from candidates, but also from other sources. And then we had written rounds of questions. And then in the end, we had a public hearing with candidates. And those public hearings, they were actually recorded and they were put on our website, both in Moldovan, in Romanian, and also in English. And so you can also follow and get a bit of an idea how these are going. So that is definitely an issue. And as I mentioned, in very big pictures, we had about 70 cases, and I think about 45 to 50 did not pass the evaluation. So that's a particularly high number, and more so with judges than with prosecutors. But we're about to finish our work, and we'll no doubt we will provide an overview of all the decisions that we have taken. And of course, when they do come out, I'm more than happy, of course, to share them with everyone. Yeah, thank you.
Thank you, Herman. I see Jim wants to add or comment something.
Thanks very much. It's so good to see so many good friends. I just wanted to add that I'm doing a bit of work in Ukraine right now, and the same is true there for some of the vetting enterprises that are underway, especially the ones that include international experts in the panels. And they are also on the internet. It's not hard to find the full interviews with individuals who are applying right now for the positions that in Georgia are analogous to the independent inspector office, right? The office that receives complaints and investigates complaints about judges. So they are creating such an organization right now. And the interviews of candidates for those positions are available on the internet also. And they are very, very instructive. I'm getting ready to travel to Kyiv probably in mid-December to do some workshops, and watching these publicly available interviews is incredibly instructive for me, especially when I'm seeing the people that I'm going to do workshops for being interviewed for their jobs. So it's excellent that these are available in so many places now, and it's an amazing, valuable resource. Thanks.
Thank you so much, Jim. Georgi also wants to comment. Please, Georgi.
Thank you, Keta. Just to add something and address something that Guram mentioned, and it's actually addition to this conversation on transparency. I was amazed to hear that court decisions are not public in Georgia. I recall that we had one online discussion maybe 1 year or 2 years ago about it, and we discussed it. court decisions in Macedonia are public for many years now. We absolved this like a decade ago, so you can access our decisions online, and it's widespread for the public. And also, what is novelty, and it was one of the recommendations from the European mission that evaluates the work of Judicial Council, that now all the sessions of the Judicial Council are public. They are streamed live, so this helps enrich our trust in the Judicial Council, and there are maybe some opponents inside of it. It's not unison as Guram mentioned. There are different opinions, but for me this is good because it shows that some things are moving forward. So it's a different situation in Macedonia. It's not ideal, but still I would like to hear that in Georgia also there is improvement in transparency that will help you in your processes.
Yeah, if you allow me, just Jim, what you mentioned, it's those interests are really fantastic to watch. If you're there, I can put you in touch with the Supreme Court Justice Ivan Mishchenko. He's the one leading the vetting commission there, and something which is a much important aspect of what has been discussed tonight is the clarity of the burden of proof. You have to know that in vetting, the burden of proof is on the judge himself or the candidate for the High Judicial Council or the High Prosecutorial Council. The burden of proof must be clarified, as well as the right of an appeal. Ukrainians had a very good discussions on that. You will see them I will send you all the reports and instruments, and basically, you will see it's very well clarified, the burden of proof and the right on appeal. So, yeah.
Thanks, Andre.
Thank you so much, Andre. Maya is writing in the chat if there is a possibility to share the link or some web addresses about you mentioned the reports. It was mentioned by Andre. I don't remember, Maya.
I think it was mentioned by Mr. Herman von Hebel. I'm interested in assessment of effectiveness of the vetting process, how it works, and what now the judiciary, for example, of Albania, like kethilsindisierības.
Yeah. I can say that the website that I was referring to is www.vetting.md. I can write it down here as well.
Okay.
This is the website.
Thank you so much.
And have a look, because all the three commissions, so the pre-vetting commission, but also the vetting commission for judges and for prosecutors, is all under this same website. And then you can click on the links to any hearings that we had with the candidates. So please go ahead and enjoy those hearings, because they have been quite interesting at times, I can tell you that. Yeah.
Thank you, Herman.
Georgi had a question about, why judicial, what happened to judicial, I just one very small comment. Georgi had a question about what happened to judicial decisions in Georgia. And the response is that we have everything perfectly described in the law. So basically the law is very clear. All decisions are public, everything should be published. You have the right to go to the court and ask for any decision you want. So the law is absolutely fantastic, but the reality is terrible. They don't publish anything anymore, except for the Supreme Court decisions. They just don't comply with the obligation of the law. And I think if you go to the court, they won't give you a decision. And also, I think that's also the big problem. So there is a problem of compliance. Yeah.
Thank you, Kapa. Irakli and then Eka, and I think this will be the last questions as we have to conclude our discussion timely. Please, Irakli.
I'm a practicing attorney. I'm not expert in how judiciary is functioning internally. I have one question. As I see, vetting is getting more popular because of corruption in especially former Soviet countries and Eastern Europe, especially. And just to deal with systemic corruption in courts and lack of independence. And it is aimed at when good governments are coming into power and they want to get rid of bad judges, corrupt judges. How to make safeguards when bad governments may use this similar vetting process against independent judges? Are there, because I have read a very interesting article of Judge Hagenloch, who is here as well, participating in the panel, published in German-Georgian Journal of Comparative Law, where risks related to vetting were clearly described. I'm sure that you are experts in this field and you deliberated about safeguards of and observing the fundamental rights of judges, candidates of judges. But is there still risks of using vetting in not proper way? Maybe. Thank you.
Thank you, Irakli. Who can comment about Irakli's question? Okay, Herman. Okay, thank you.
Yeah, I think that is an incredibly important question. And I think the experience in Poland has also seen, of course, how processes of governments trying to interfere with the judiciary. I think there should be a fundamental hesitation about these kind of processes. That's also why in my introduction I said, these kind of processes should only take place under exceptional circumstances when there really is a fundamental problem, widely perceived fundamental problem with the trust in the judiciary. This is not for governments to get new judges in there who are close buddies to the political parties, etc., and then every new government can come there again. We've seen the situation in Poland, and now in Hungary it is happening. And you could also see the new government in Poland actually struggling with changing the system because they want to make sure that they do it in the right way so that it is not perceived as every time there's a new government in Poland or any other country, they start all over again, and then you have the same problems. And of course, that is also what you also mentioned, and what we see now in the discussions in Macedonia, with the new government saying, "Oh, let's change the composition of the Judicial Council and the Prosecutorial Council." No, that should not happen. There should be fundamental guarantees. It should be about the process. I think personally, and of course, I'm a judge in my own case, that I think international members of commissions are an incredibly important aspect to that. Because I was, in Moldova, the first time I came to Moldova was when I became the chair of that commission. I didn't know any lawyer in Moldova. And that was good because I didn't have any association with anyone and whatever. And I think that is the element of independence that is required. I think that is one guarantee. So bring a few internationals in there. The other one is make sure that those procedures are really up to international standards. We have constantly looked at Article 6 requirements, and that is necessary to do so. I think these are some of the guarantees. But there again, you have to be careful, and it can equally be a very well misused instrument by governments who don't like the judiciary to be independent. So it's a delicate balancing exercise, but those guarantees have to be in there, absolutely. I hope that answers your question, Irakli. Yeah.
If I can just intervene, Herman, you're on point, exactly. And this question is, vetting would never existed if the Judicial Council performed a constitutionally assigned role it was designed to perform, which is the safeguarding the independence of the judiciary. That's it. That's it. However, Judicial Council, out of that institution, has converted themselves, especially as we've seen in Macedonia, as a mechanism for a direct control of the judiciary by the government. And here lies the problem. And I'm putting my faith in vetting proceedings because there are international experts in the vetting commission as well. And every member, especially when it comes to Judicial Council, that is pre-vetting. Vetting is for all the members of the judiciary, all the judges, 700 judges, 600, whatever. But pre-vetting is only for 9, 10, 12 members of the judicial councils and prosecutorial councils, which you vet those candidates. If you want to be a member of the prosecutorial judicial council, let's see your financial history. Have you paid taxes? For example, I know in Moldova, Herman knows the case. I'm not going to mention the judge, although you know who I'm referring to. He reported that he was... as in his student days, he was importing bikes into Moldova. It turns out to be luxury cars from Germany into Moldova, and not paying taxes. You go financial check, you go integrity check, affiliation with religious affiliation, extremist religious affiliations, or association with political figures. How were you appointed? As a judge, or your personality, and your integrity check, which means that are you following the rules of ethics which are established and enshrined into the code of ethics for judges. So basically, that's it. I wouldn't go, my suggestion and recommendation would be, especially in the case of Georgia, do a vetting of the Judicial Council and Council of Public Prosecutors so they can assume their constitutionally designed roles and clean out the judiciary themselves. And of course, never forget the support of the NGO factor, the NGO sector here. Organizations such as Unity for Judges, if I'm not mistaken, Democracy Index for Georgia, and other organizations who play pivotal role in monitoring these processes and reporting on these processes. So basically, it's a comprehensive effort, but damage will be minimized with pre-vetting. If we go into vetting, the judiciary, be prepared to be on a hold. If you have a claim in front of court, be ready, be prepared for that claim to be resolved after 5 or 6 or 7 years. And by the way, you cannot complain that you haven't received trial in a reasonable time, because constitutionally the judiciary is under vetting, it's under scrutiny, and such standards as trial in reasonable time does not apply in your case. So basically, as was the case in Albania. So basically, if Georgian authorities are deciding which type of brand of vetting should they adopt, pre-vetting is the most painful and effective mechanism, which can only cleanse the High Judicial and High Prosecutorial Council without infringing the entire independence of the judiciary. Put good people in those councils, they'll take care of the judiciary, they will resume their own work, they will do it by the book, and they will cleanse the judiciary of corrupted and bad actors. Yeah, that's only intervention. Thank you.
Thank you so much, Andrei, for your recommendations. I think the last question will be from Eka. Eka, please, we're listening.
Just very brief comment. Andrei seems to be a very strong believer in vetting. I like that. But I have 2 short questions. When we talk about alternatives to vetting, do you think there is a different degree of political will needed to have it? Because we already have an institutions in place, we don't necessarily need revision of the constitution, or even maybe to amend laws in order to have alternative vetting procedures in place. Do we are we also talking, when we talk about alternatives to vetting, are we also talking about lesser degree of political will needed to conduct that procedure? This is one question I have, and the other, and for whoever would like to answer that question, and for Herman, I would ask him about his opinion when integrity of candidates are checked. Do you think it's effective to check their integrity on a financial basis, the financial side of their activities and life, or it's for the full effectiveness, it's also necessary to look into their judgments, their decisions, and evaluate those as well? Thank you.
Thank you, Eka. I think that Herman will answer the second question, and the first, Andrei. Okay, Andrei, please.
Okay. Eka, basically your question is which road is it's more safer? I would say political will. Of course, you need political will. We are all political beings, you know, Aristotle, zone politikon. So basically, political will is needed. You cannot, you need to engage in discussions, healthy discussions with the government. You know, you need to have a prepared plan. If the pre-vetting proceedings are only requiring amendment of the law on judicial council by establishing a special commission which will review the candidates for council. If, for example, if the current composition, the mandate expires, for the new members that must come into the council, they must pass this special vetting, pre-vetting commission, such as was the Herman Commission in Moldova, where it's only the candidates shall be reviewed. That means that only changes into the law on judicial council are needed. If you're doing pre-vetting of the members of the current sitting members of the Judicial Council, then constitutional amendments must ensue. But for everything of this, you need consensus and you need political will in the government and open negotiation and constant negotiation with the Ministry of Justice and representatives of the NGO sector. It is a comprehensive, holistic process which everybody must be involved. This is not a prerogative of the government, nor the prerogative of the judiciary. They all must be involved into this process. If it comes to opening the constitution, which I know it is very, very disputable problem, as we saw in Albania and we saw in Moldova, where the prosecution, usually the government is the one who says, no, we don't want foreign interference. We don't need foreign interference. We can handle the problem yourself. And the opposition always states, if you could handle the problem yourself, why didn't you do it? And pre-vetting is the only decision, the rational decision which can be taken into this case. For example, take Judge Bakradze's case. It's not the entire judiciary fault. It's the fault of the Judicial Council. The Judicial Council was the one who didn't approve her appointment. It wasn't the entire judiciary. So that is why, you know, political will, consultation, open dialogue with parties, and to proceed this. Thanks. I hope I was clear. Please let me know if I can explain anything else. Thanks.
Thank you, Andrei, so much. So Herman, please.
Yeah. Thanks, Eka, for that question. I think we actually looked at two different aspects: is the financial integrity and the ethical integrity of candidates. And actually, in practice, the financial integrity was the easiest. You know, you could check, and we had access, for example, to bank accounts information, to the information from tax authorities, from the integrity authority, to which judges on a yearly basis have to provide an overview of their their declaration of assets, etc. So these are relatively easy exercise to do. It's a lot of work, but it's doable and it's relatively straightforward. And we were able to go for 15 years back. So we sometimes had huge piles of bank figures of people, and sometimes they had 12, 13, 14 different bank accounts and whatever. And of all of those bank accounts, we had all the information from years back. So it was sometimes looking for a needle in the haystack, but it was a doable exercise. And it is relatively straightforward. Ethical was a bit more problematic, and it actually goes back to the question that we dealt with before. A typical ethical issue was, what if a judge was working under the instruction of a precedent to have a particular outcome of a case? These kind of issues, or, a judge, a case that I was dealing with where a judge was buying a real estate property where a law office was based in, and the judge had to pay in cash a much lower price than the official price for about a year. Every month he went to this lawyer in order to pay in cash some money. And then during that period of 1 year, that lawyer appeared before him in cases, and that judge always found in favor of that particular lawyer during that period of time. That's a clearly ethical issue. The judge was not convinced about it, but I was convinced about it, and my commission was thankfully convinced about it. But it's a clear example of an ethical issue. But sometimes there's also a bit of an overlap. Not declaring your assets in a proper way is both a financial aspect, but it's also an ethical issue. As a judge, you have to be transparent about your financial issues and assets and all that. That's also an ethical aspect. But again, your question is then, did we actually look into judgments of judges or prosecutorial decisions? We hardly did so because we were not seen as a sort of fourth instance, institution. We were not looking at, we sometimes had cases where judges took decisions and later on those cases were overturned by the European Court of Human Rights. Well, the mere fact that you were part of a panel and that decision later on went to the court in Strasbourg and was overturned in itself does not mean that decision was utterly wrong. That you can have legal interpretations going one way or the other and whatever. That is not a problem. It's only in very rare cases where it was abundantly wrong for a judge or a prosecutor to act in a particular way that we looked into that issue. But we only did so in extreme, abundantly clear cases. But, if you have a normal interpretation of the law, the normal interpretation of the facts, where as a judge, you can always disagree with your colleagues, you can always have an appeal and all these kind of things, we stayed away from that. Only in exceptional cases we did so. And I think in total, we probably did so only 2 or 3 cases of all those 60, 70 instances. So it shows we really try to stay away from that. And that is more, because that is also more of an issue for a judicial council when people are, being discussed for promotion. If judges on a very regular basis take bad decisions, that may not be the best candidate for a promotion. In that context, a judicial council may look into that, but not for us from the perspective of pre-vetting or vetting. I hope that answers your question.
Sorry, Herman, did you take a look at that? Did you have any case of chronism in the appointment? During the appointment, did you discover any chronism during the appointment?
Well, we didn't really look into those issues of appointments of judges. So we were only looking into whether their financial issues, their ethical issues were correct, and whether, if they passed, then they were suitable for being elected by the Assembly of Judges or the Assembly of Prosecutors, And we also were not looking into the question whether those people were suitable candidates for a leadership position in the council. We have had cases of judges and prosecutors, we'll obviously not mention any names, where I think, absolutely clean. But is this a judge or a prosecutor where I think that would be a strong leader for the judicial or the prosecutorial, effective functioning? No, but that was not our role. We only looked at the financial and ethical aspects, and we didn't go beyond that. Yeah.
Thank you so much, Herman. For us, of course, it's very difficult to let you go because we have a lot of questions, and it is so interesting to hear from you the recommendations and your experience, but still we have to close our discussion. I will not go in the details and far. I will just thank you again, Andrei, who has gathered and leaded this discussion and gathered such amazing our speakers, Herman, Georgi, who are the really very interesting speakers today, and very for us it's significant to have you today on our discussion, especially in this tough situation for Georgia, when we are more and more, it is becoming obvious that without independent and accountable judiciary, we cannot go further and build democracy in Georgia. Also, I want to thank Jim, who is always with us from the beginning of our activities in the network, and for recommending me such amazing members of our network, and thank you again for to everyone, our very interesting participants. To Maya, I will also just want to say that it was really very great achievement for her in this case, and congratulations again for your success. Guru was, I think, also involved in the process, and also congratulations to Guru, and thank you, Guram, for sharing and to updating us where our judiciary is now, how we can help, and what is the next steps for our situation in Georgia to overcome these challenges, which is really very big in our judiciary. Thank you again to everyone. I hope that we will meet soon again in our next discussions, and looking forward, of course, to see you all again. Thank you again, and goodbye.
Thank you, Keto.
Thank you, Keto. It was a great pleasure.
Fantastic.
Thank you,
Fantastic pleasure.
Bye-bye.
Thank you.
Bye, Keto. Bye. Bye.